Welcome to America's Heroes Group.
And we are back, America's Heroes Group, Roundtable with our partner, VETS. That's the Veterans Employment and Training Service. August is National Wellness Month. Today is Saturday, August 27th, 2022. Our host is Kelley. I'm Sean Claiborne, co-host. Our executive producer is Glenda Smith, and our digital media producer is Ivan Ortega of Scouts Honor Productions. And we have a panelist with us today. That is William Kenan Torrans. He's a U.S. Army Operations with Desert Storm, Desert Shield, and also presently serves as the Director of the Veterans Employment and Training Services, VETS, Compliance and Investigation Division. And we're going to talk about the Uniformed Services Employment and Reemployment Rights Act, USERRA, otherwise known as. How are you doing today?
I'm doing all right. Yourself?
Pretty good. So a lot of guys have returned back from Afghanistan, and a lot of people were National Guard, and like I was, or reservists, and they had problems going back to their jobs. So what's going on with that? Tell us about the act and what it means.
Okay, well, happy to. The Uniformed Services Employment Employment and Reemployment Rights Act, USERRA, does three basic things. And if you understand these, then you understand the statute. The first thing the law does under Section 4311, 38 U.S. Code Section 4311, is that it provides that employers cannot take any adverse action against any current or prospective employee due in any part to that individual's past, present, or future military service status or obligations. Now, under that part of the statute, the service member, the military service does not have to be the major reason for the adverse action. It could just be a small part of it. But in any event, if the employer takes an adverse action against the employee doing any part of their service, that's a violation of federal law. Okay, that's the first thing. Very similar to Title VII violations. Race, creed, gender, that sort of thing. The next thing the law does is that it provides that individuals who leave their pre-service civilian employers to go on periods of active military service and who meet the 5 eligibility criteria for reemployment have to be promptly reinstated in the same position of status, seniority, and pay they otherwise would have had but for that period of military service. Okay? And that means any latter pay raises, that they move forward. It's like the Family Medical Leave Act in some respects, except that under FMLA, the Family Medical Leave Act, which puts the individual back where they were when they left, USERRA puts the individual back where they would have been had they never left. And this has been the law since 1946. It was a seminal Supreme Court case, Fishgold v. Sullivan Dry Dock. And in that case, I'll just explain very briefly. Fishgold was a ship fitter with Sullivan Dry Dock before World War II. The war broke out, and he was drafted into the Navy. Did his time in the Navy, and then he came. And in 1945, he came back, demobilized, and seeking his job back. And Fishgold and Sullivan Dry Dock said, "No, we can't. You're demobilized, and we've laid off everyone." Well, the Supreme Court determined that not only are you're entitled to return to your civilian job as if you never left because you went to serve the colors. You have additional rights that you otherwise would not have had. However, in this case, the escalator position is neutral. It can go down as well. So in this case, what happened after World War II, all these businesses lost their War Department. It wasn't DOD back then. It was the War Department. Mm-hmm. They lost their contracts with the result that they had massive layoffs. And they were able to show that his proper escalator coming back would have been a layoff. It can go both ways, but in most cases, it has a positive result. And then the third thing that the law does, it prohibits adverse retaliation, which basically means that an employer cannot take any adverse action against any employee, regardless of their military status, for either asserting or having asserted or having helped someone else assert his or her USERRA rights. And the federal sector, it's also a prohibited personnel practice that's separate and apart from USERRA, and that's enforced by the U.S. Office of Special Counsel.
Wow. So is there a lot of do employers not like this, and does this create any kind of any kind of hesitancy for some employers to hire veterans or hire somebody that they know is in the military? Do you see discrimination in these cases?
Well, we do have. I can't speak to the reasons that an employer may not do that. Now, there is a question, for example, as to whether or not an employer can. It often comes up whether the employer can or cannot ask the individual, the prospective employee, about his or her military service, i.e., are you a veteran? Are you in the Guard or Reserve? Well, the answer is yes, they can answer that question. They can ask that question, and the prospective employee is obliged to answer honestly. But if for any reason the employer does not hire them, then they file a USERRA complaint, the employer is going to be on the hook to explain why they refused or didn't do that. Mm-hmm. Now, it doesn't mean they may have had valid reasons for not doing it, but if their military service was a reason, that's a violation of the statute. And 4311, what we call the section 38 U.S. Code, section 4311, is the USERRA anti-discrimination section. And those cases really are difficult to are probably the most difficult of any case to investigate and substantiate. Mm-hmm. But we do quite often. And in our annual report to Congress that just came out this month, in the first of the month, we lay out all the case numbers, the numbers of discrimination cases, the number of reinstatement, and so forth. We break it down in minute detail.
Wow. So one of the things that I think is kind of amazing, one thing I heard about too, that a lot of veterans talk about, when you go into the military, it's like you're in a time capsule, because when you go into service, and you kind of talked about this a little bit, when you leave, and particularly if you're deployed, but even if you're just gone for just training, when you go, it's like you're in a bubble, so you don't know what's going on in the world, and the world's moving on without you. Like, I've heard stories where guys have come back from previous tours, and they really never seen a cell phone before. And they didn't realize that there was smartphones out. Like, when they left, there were flip phones, and they came back and they were like smartphones, and they're like, what is this? Like, what's going on? And then, but at the same time, the workforce is also evolving and changing as well. So when people are coming back to their old jobs, a lot of employers have been saying that, you came back, but you don't know how to, use this computer or this new software that we've been using for the last 2 or 3 years, or God forbid, you've been gone for 6 years. Now, our workforce is totally different. What do you do in cases where when employers will say you're now obsolete because you don't have the skills? You were out, doing what you were doing in the military, but now you're obsolete because your skill levels haven't evolved and the whole workforce has changed.
Oh, well, that's a big no-go. If that happens, the employer is obliged under USERRA to promptly reinstate those individuals in the same position of status, seniority, and pay they otherwise would have attained with reasonable certainty had they remained. Okay, and the employer is also obliged to get them up to speed, to give them whatever training they may need on a reasonable basis to serve in that capacity. So the one thing I would footstop here are the 5 eligibility criteria for reinstatement. And I'm taking a little diversion from the question, but we're going to circle back to it, okay? So essentially, number 1, the individual has to leave civilian employment to perform covered military service. And that's really any military service under orders, all right? The next thing they have to do is they have to provide notice, advance notice, to their employer that they're leaving. Now, it can be oral or in writing. We and everyone else encourage the service member to put that in writing to avoid a he said, she said scenario. And then, and they're not obliged to provide copies of orders. We encourage them to do it. DOD encourages them to do it, but they're not obliged to by law, and the employer cannot take an adverse action against them for failure to do that, okay? Then the next criteria, they can serve up to 5 years cumulative on active duty and still retain reemployment rights. And they're subject to a number of exceptions. Stop loss, involuntary retention on active duty does not covered. Traditional Guard and Reserve duty not count toward that, or anything like that. Involuntary retention and voluntary or involuntary service performed in or in support of wartime or national emergency. So that would have been Iraq, Afghanistan, all of GWOT, Global War on Terror, any of those, and that duty would not count against that 5-year cumulative service limit. And remember, it's a cumulative service limit. And then they have to they cannot have a disqualifying discharge, which means bad conduct, dishonorable, other than honorable. Those will cancel out any rights under USERRA if they get those. One of those. General discharge, uncharacterized, medical, those are all good to go. And then the last thing is that they have to report back to work in a timely manner. Now, under the law, it states basically that they have to submit a timely application for reemployment. And that's kind of a misnomer because they're not applying to get their old job back. They're really just telling their supervisor or the appropriate person in the chain of command that they're back and they're ready to come back. And it has to be done in a timely manner. So if they were gone for up to 30 days or less than 30 days, then they have to show up at the next work shift with enough time to rest and recover after periods of duty. So if your guard shift ended, or your duty ended at midnight on Sunday, and your shift starts at 2 a.m. or 5 a.m. on Monday morning, then you're going to have about 8 hours to rest and recuperate before coming back.
I got cheated.
That's a good thing. And then if the duty period is between 30 and 180 days, they have 14 calendar days, 2 weeks to report back, or to let them know that they're ready to report back. And if they were gone for 180 days / 6 months or longer, then they have 90 days to report back to work or let them know. And during that, they can take all of it, part of it, or none of it if they want to. Their call to do it. So when they do come back to work, the employer is obliged to put them back in that escalator position, and it is never a valid reason for the employer not to promptly reinstate them if during their absence the employer hired somebody else to do the job. They really like that person, and they say, well, yeah, we'd love to, but we fill the position, we can't bring it back. No go. That doesn't fly, and they do have to take all necessary and reasonable actions to get that person back up to speed to do that escalator position job.
That's amazing. Yeah, I got cheated a few times on that one, so maybe I don't know if there's any recourse at this point. Now
we can talk about that.
now, one of the things that I was reading about, and I hear that there's a lot of these little agreements and employment contracts for arbitration, and how arbitration can be used to circumvent USERRA. So if you sign an arbitration agreement with an employer and that you get wrongfully terminated, you come back to work and maybe they let you go 6 months later. Maybe they wait a few months before they let you go. Because of your arbitration agreement, now you can't just say, well, you can't fire me because I was doing my service. Now you have to go before an arbitrator who's going to make a decision instead of going through USERRA. How is that playing out?
Well, we're actually not seeing that as an impediment to our investigating complaints. Now, just to jump ahead just a little bit, in our annual report to Congress, we did include, and at the very end of it, in our legislative recommendations that we submitted on behalf of ourselves and the Justice Department, a provision that would clarify that USERRA trumps any private agreement, contract, or other that would circumscribe or otherwise lessen its protections. Now, there was a case, I believe it was Garrett v. Circuit City, the seminal case on arbitration agreements that occurred right around, I want to say, 03, 04, 05, in that time frame. No, I'm sorry, strike that. It was 05, 06, in that 2005, 2006. In which the plaintiff, a Marine captain, was worked for Circuit City, which is now defunct, and they had took issue with his military service, and he sued in federal court. And Circuit City argued for dismissal at the general district court level that he had signed a binding arbitration agreement that precluded him from filing suit in federal court. They had to go through an arbitration. Well, the district court held that he had USERRA rights and that he could sue on his own behalf. The Circuit City appealed that to the Fifth Circuit, I believe, and ultimately the Fifth Circuit held that right to sue is a mere procedural right, and USERRA's supremacy clause did not really apply there. And since that time, there have been a number of differing decisions split in the circuits, among the federal circuits about this, and it needs cleaning up. So we recommended that, one, there's the FAIR Act, which we addressed in our annual report to Congress. But one of the things we said in an alternative, the statute should be amended just to clarify that USERRA applies to both procedural and substantive rights. So that would clear up. That would just, for consistency, along with the statute. The language in the statute is fairly clear. In fact, we cited the lower Garrett decision in our justification and our regulations when we first published those back in 2005-06 in the preamble. So it's our position that our position in the Justice Department position that USERRA does trump those kind of agreements. Now, we have not had a problem investigating cases. For example, when we see that that there is a binding arbitration agreement, we have not had a situation where the employer says, no, you can't investigate. And it's in their interest to have us do that, because in the investigation process, we're neutral. We are Switzerland, okay? Mm-hmm. We are not advocates for the employee. We're not advocates for the employer. We're advocates for the law. And USERRA is probably the most employee-friendly labor employment law in the books today. And it can be a tough law to comply with. And we really try to help employers do that. And the vast majority want to do the right thing by their employees, their service members. They really have been stepping up.
So how do people contact you if they need help and they feel like that they are wrongfully terminated, but they really don't know that they have any kind of recourse? Because oftentimes it can be intimidating and kind of daunting, particularly for a veteran who's used to following orders, used to being told what to do, and then all of a sudden they get laid off or let go, and they feel like, well, they just don't want me, and so how do people get in contact with you in order to get help? Well,
sure. Well, we have, that's easy. Let me first say that we're just a phone call or an email away. We're easy. And we have on our website at www.dol.gov/vets, I'd say again, dol.gov/vets, we have a USERRA page, and we also have the direct dial contact information for all of our staff members. And so everyone on my staff has a direct line there. I have a direct line. All the field staff out there, we have over 200 people out in the field. And each one of those has a direct dial phone number that's on that website, dol.gov/vets, under contacts. And I encourage people, if they have an issue, to reach out to them. And then they can also look at our USERRA page. It's a wealth of information. When they call us, they get a live person. There should not be any voicemail or email tree to get through. They'll pick it up right away. They should be. Now, sometimes we have small state offices, like small states like Rhode Island may not have but one or two people in there, but larger states do. Now, the other thing I would add that there are a ton of resources out there for folks that need help. I would also make a plug for ESGR. That's a DoD agency, Employer Support of the Guard and Reserve, and they do super work, and they do a lot of intervening on employees' behalves. Now, one thing I really want to foot stomp, our goal, we're not out to get big settlements for people. I mean, sometimes we do, but what we're really looking to do is preserve that employer-employee relationship wherever possible, because that keeps everything spinning, the economy and everything else, and that keeps everyone employed, and if the relationships are preserved. In that regard, when things go to litigation, they've gone nuclear, and they become adversarial, and it really puts a strain on that relationship. But if you resolve these case issues at the lowest level possible, then that preserves it. And so many of these disputes are really the result of a lack of understanding between the respective parties, employers, employees, about their rights and obligations under the law. And a lot of times we can clear that up with a phone call or an email. And ESGR has, and their website is www.esgr.mil. and they have a nationwide network of hundreds of volunteer ombudsmen who are educated on the law. And what they will do is they will take the information from the service member or the veteran, and then once they get there satisfied that they have what they need from them, they don't investigate. And once they find that, then they will go out and they will they will talk to the employer and try to bring the two and try to find out, get to the rub of the situation and sort it out appropriately. Now, individuals can always file a complaint with us on our website. We have an electronic complaint form, the E1010, E as in Echo 1010, and they can complete that and submit it online without having to file a paper copy, hard copy. And of course, if they have other documents to submit, they can upload them. But they can also, once an investigator is assigned, they can submit to that person as well. And we have a standard when we get those complaints. We'll promptly open up an investigation on their behalf, usually within 3 to 5 business days, and then we will. And our investigations are like any other federal civil investigation or IG Inspector General investigation. We collect all evidence, all hard copy documentary evidence, and we'll interview witnesses that are identified and have information pertinent to the issues raised. And we have subpoena power. So if there's in those cases where the employer is reluctant to provide information, they get hit with subpoena, and we use it when we have to.
So do you see that? Do you usually see employers? Are you able to resolve things most often pretty easily with employers? Are they pretty receptive once they understand the law? And you've explained it to them and everything.
I believe that's right. We have when we investigate a complaint. We don't use the word merit or non-merit. We use. I really am a big fan of the Army Inspector General and the way they operate, and which is very similar to the way we do, teach and train and all that. But we seek to gather the evidence, and if the evidence we gather substantiates the allegations raised, then we will work with the employer to make sure that the employee gets what they need. We have a very good track record in resolving those substantiated complaints, and when I think it's in the almost 90% or higher.
Wow.
And even if we are not able to resolve a case to the claimant's satisfaction, or if the claimant is not we find the evidence does not substantiate the allegations raised, they have the absolute right to request that case be referred to the Justice Department in the case of non-federal cases, or to the U.S. Office of Special Counsel for federal sector cases for a complete brand new review. In the lawyer world, they call it de novo, but it's brand new review. They just look at the evidence, and then they decide whether or not they're going to offer representation, either in U.S. District Court or before the Merit Systems Protection Board. And so they have that. In addition, the claimant can always go to private counsel at any point in this process. They don't have to come to us, or they can come to us directly, and we'll take it from there. And a lot of times, but we have a very good track record on resolutions.
Wow, I really appreciate that for all the work and everything you guys are doing. Because I think a lot of times as well, employers, because we have a country where less and less people are serving in the military. The veteran population is actually shrinking. So we're losing veterans, at a rate of I think a few million every few years, roughly, like a million every 2 or 3 years, I believe. As our veteran population gets smaller and smaller, and fewer people are signing up to serve. That means there's fewer employers who really understand and can sympathize with the veteran experience and what that means to the country and important things that we do as veterans to support our nation. So I really appreciate all the work that you're doing. William Kenan Torrans, U.S. Army Operations, Desert Storm, Desert Shield. He's a veteran and presently serves as a director for the Veterans Employment and Training Service, VETS, Compliance and Investigation Division. Thanks for your time.
Well, thank you so much. Anytime.
Appreciate you.